You ready?
Yes, Judge.
Let's roll, nerds.
All right. First, we have on page 2,
Yeah.
Blewett. Sure, I'm ready. Come on up, please. Page 2.
Judge, I heard you ready on that one?
Yeah, Blewett. Good morning, Ms. Blewett. Ma'am, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am. Okay.
Thank you, Judge. On March 31st, 2025, in Harris County, Texas, officers were dispatched to an assault in progress call. The officer met with complaining witness 1, who stated that he, the defendant, and the other complaining witness were in a polyamorous relationship. The first complaining witness stated that the defendant had sent numerous texts and calls and showed up unannounced at the residence. The first complaining witness stated the defendant had struck him in the face while the defendant had a phone causing pain and a tooth to become loose. The second complaining witness stated the defendant arrived at the residence, and while complaining witness 1 was trying to calm down the situation, the defendant struck complaining witness 1 in the face, and in the process of breaking the fight, the second complaining witness was struck on the shoulder, causing pain.
But we only have the assault on the gentleman, correct?
But the assault's only on the, I'm sorry,
The gentleman.
I believe so,
You
yeah.
only got one count.
Yes, sir.
Okay, Ms. Blewett, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you, there's a protective order that has been issued in this case. You need to get to know it. If you do something to violate the protective order, the state can and probably will file additional charges against you. Do you understand?
Yes, sir.
I'm ordering you not to have any contact with this person and not to be in possession of any weapons. If you violate this, I will revoke the bond, put you in jail. No more PR bonds for you, ma'am. Do you have the ability to hire a lawyer?
Court appointed lawyer, court appointed.
Do you have the ability to hire a lawyer? Okay, I can have you fill out an application. I'll take a look to see if you qualify. I need to know everything about you, how much money you have in the bank, how much money you work, and I'll take a look if you qualify. I'll have you sign a receipt. Victoria, Deputy Miranda is going to give an application, and I'll have you take your seat in the jury box. Do not leave until you sign our bond condition. Can you file no contact, no weapons, please?
Yes, sir. So no contact, no weapons.
Yeah.
All right, Judge, next is page 3. Delane. Come on up.
Good morning, Mr. Delane. Sir, you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you, Judge. On March 31st, 2025, in Harris County, Texas, a law enforcement officer responded to a trespass at a gas station known for being a drug trafficking hotspot. Law enforcement officers witnessed surveillance footage of the defendant making multiple hand-to-hand transactions and throw something in his vehicle when the law enforcement officers originally approached the gas station. The law enforcement officers detained the defendant and approached the vehicle and witnessed 2 sacks of marijuana on the passenger floorboard area in plain view. A probable cause search was carried out, and the officers identified the 2 sacks on the passenger floorboard as marijuana. The total weight of marijuana was 76.37 grams.
Okay. Mr. Delay, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you not to go back to this gas station. Do you understand? I'm also ordering you now not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will put you in jail. Do you understand?
Good.
No more slinging. Do you understand? What do you do with yourself these days? Do you have a full-time job?
I'm doing application right now. I have an interview tomorrow.
Good. I'm bringing you back in 2 weeks, and I want to see that you have a full-time job. Do you understand? If you come back and you've done nothing, it's not going to go well. And I'm telling you, I'm going to drug test you within the next 50 days. If I find that you continue to use, it's not going to go well for you. You understand? All right. Did you want to apply for a court-appointed lawyer? Okay, Deputy Miranda's going to give you an application. I'll have you sign a receipt with Victoria. You will then meet with Fleischer for your bond conditions. I'm also ordering you not to be in possession of weapons as well. Do you understand? Okay, come on.
Go ahead and claim. All right, Judge, next is page 15, Phillips, come on up.
Mr. Delane, did you graduate from high school? What, you said 15? Vic,
He obtains GED.
what's
He
your,
obtains GED.
yeah, but hey, 15?
Oh, I'm sorry, Phillips is on page 15.
Yeah, okay. You're, Mr. Phillips, you're charged with failure to stop and give information, leaving the scene of an accident without exchanging information. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Judge, on September 1st, 2023, a law enforcement officer responded to failure to stop and give information call in Harris County, Texas. The law enforcement officer made contact with the complaining witness, who stated that she was pulling into a parking lot of a corner food store and observed the defendant's vehicle reverse into her direction quickly. The vehicle then rammed into the rear driver's side of the complaining witness's motor vehicle. The defendant's vehicle then quickly shifted into drive and fled the parking lot. The complaining witness took a photo of the rear of the defendant's motor vehicle after the accident and provided the license plate to the law enforcement officer. Law enforcement officer found the motor vehicle registered to an address less than a mile away and traveled to that address and made contact with the defendant. The defendant stated he was at the food store with reversing out of the parking lot and struck the complaining witness. The defendant stated he fled without providing information because he did not have a driver's license. The defendant was identified with his Texas ID.
So can you run his license, please, just to make sure?
Yes, Your Honor, I'm just not showing the driver's license numbers, so I'm not sure if he is part of the license since then, but we don't have it in our system.
If you do not have a license, do not drive. I don't care what's going on in your life. I don't care that you have to go to work. I don't care that a baby needs to go to the hospital. I don't care there's a burning building and you need to save 50 kittens. If you don't have a license and liability insurance, do not drive. You will be signing an affidavit with me today. This is the promise that you're going to make, that you're not going to drive. You cannot justify getting into a car for any reason. And if you do, you can be facing an additional 6 months in jail on a contempt charge. Every time you drive, it's an offense in and of itself. Do you understand? What do you do with yourself these days, Mr. Phillips?
I work and take care of my little sisters. My dad had recently passed away.
Do you have a full-time job?
Yes, sir.
Did you graduate from high school?
Yes, sir.
Okay. Did you want to apply for an appointed lawyer?
Yes, sir.
Okay. I need you to qualify. I need you to fill out an application. I'll take a look to see if you qualify. I need to know everything about you. Do not drive, Mr. Phillips. If you want to drive, go get a license, get insurance, show me that you have these, and then we can talk. But until that point, don't do it. There's going to be HE double hockey sticks to pay if you do. You understand? All right, come on.
Judge, so it's just a no driving affidavit. Next judge is page 21. Wilkins, come on up.
Judge, to clarify on that first one, just no contact.
Correct.
Charges, yes.
No contact with complaining witness and then no weapons. Vic, what's the last name on the gentleman?
Wilkins,
Got it.
page 21.
You're Christopher Wilkins.
Yes, sir.
Wilkins, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On May 20th, 2024, officers were dispatched to the address of defendant's stepfather. The complainant was stated he confronted his son about missing items. The complainant was told the defendant to get ready for rehab. The complainant was noticed his jazz bass guitar was missing and observed his neighbor's cameras, which showed his son to leave the house. The total value of that guitar was $480. That was all I have on this one, Your Honor.
Do we know he did it?
Your Honor, it stated that there was.
So dad is saying there are several items missing from the house.
Yes, Your Honor, including a guitar.
A bass guitar.
Bass guitar.
Anything else?
Yes.
Does dad call the cops on his own son?
Oh, Your Honor, it was.
Stop.
Oh, my fault.
Stop. Don't
Fault.
say a word. Are you losing? So why talk?
I'm not sure how the police were contacted here, Your Honor. It just says that they met and spoke with the complaining witness.
Another report written like it's just going through a drive-through.
So, Your Honor, the only thing I would say is, she's facing the VIMs. The defendant had initially declined any of the allegations, but later told his mother that one of the items that was stolen, which was a bicycle, was, later stolen from the defendant when he left it at his store.
But here he's charged with a bass guitar. What the?
Okay, Your Honor.
Have a pet lizard named George. Really? Mr. Wilkins, I'm going to find that there's no probable cause to go forward in your case. This life is a very short life. And when you start racking up convictions, it really hoses you. It's really hard enough as it is as a black man in today's society. And when you start racking up convictions, especially theft convictions where you're branded a thief, do you think it helps? No, it doesn't. Get into school, get some knowledge, get a degree, find something to do, and make a lot of money. That's what life's about. Not ending up in court with a theft charge. You know what I mean? If you have a drug problem, address it before it becomes a real issue and it takes a hold and grabs you by the boo-boo. You know what I mean? Plenty of people in there. We don't need any more. Please.
That was the last arraignment, and now. Counsel for reset? Phillips? Clarissa? Clarissa?
Good morning, Mr. Huang.
Good morning, Judge.
What's going on with you?
I have requested a plea, but we don't have one yet, offer. So
We're talking about Quinn. H.
on my case,
Do you have an offer on the case?
One moment, Your Honor.
Bullet?
Sure.
Judge, what's the last one?
Bottom of page 8.
Teresa?
Lewis? Please step on the line.
Yeah, take your time.
Go ahead and sign
I apologize, Judge. I was in court 4 and just sitting there for a while until.
Don't worry about it. You're good. We're glad that you made it. Did, hey, Vic,
Yes,
did Stradley come here today?
yes, he reset it.
He already left?
Huh?
He already left?
Yeah, he already left.
Okay. Because we need to do conditions. It's a second.
I can't hear you.
It's a DWI second. We need to do conditions. I know, but I still want to put conditions. He's gonna bond out, I would imagine, right? No, but I'm putting conditions first. I want to get conditions so we get a guardian interlock and now. Yeah, see, yeah, I mean, I want to put conditions on, you know? And if you can't say that we can give him someone in the interest for now, just for purposes of conditions, okay? It's okay, Tom.
Tom, hear me?
Shh. He can hear you.
Tom, I'm gonna send you an email on this one. I think we've got it worked out. Let me send you an email on it.
All right.
Just let me know when you're ready, okay? Hi.
Thank you, Judge. I just wait here in the link.
Come on up. Yes, ma'am. Good morning.
Good morning, Judge. I'm here on an off-docket matter. Is that okay?
Yes, okay, of course. What's your cost number?
There's two and Judge, hang on.
I forgot my eyeballs too.
There's a DWI and that's cause number 2556097. There's a tampering.
This is on Mr. Hernandez?
Yes, sir.
Are you representing him on both?
I am, and Judge, we just realized, I'm sorry, my staff, I just filed the notice of appearance on the tampering. We didn't realize they had two.
We have you connected.
Okay.
It looks like he has an ice hole.
Well, yes and no, that's why we're in front of you. So he apparently posted, maybe the PR bond here. ICE got him from the jail. He went to immigration.
Oh.
And April 2nd, posted a bond there. But we've got two warrants. I believe these warrants are holding him. And so didn't know if, I think Harris County maybe has 10 days. I don't know for sure. They have a
So
certain number of
what
days.
happens is that you don't get notice, or I guess we didn't realize that he's in immigration. We assume that he's out, he's gone on the lam.
Right.
So
And they didn't
we
have
issued
a
a
warrant
warrant.
to tell you, Judge, so.
So he's made bond on the immigration case?
Yes.
Okay,
yes.
so I can reinstate these bonds now,
Okay.
but as soon as he gets out, he needs to come here immediately for bond
Of
conditions.
course, okay.
So we need to set a day.
What's the case number?
You ready?
Yeah.
It's 255-6097. There's two. I'll reinstate it now, but if he's not here by the next setting, let him know that I'm gonna end up revoking him because he needs to come here for bond conditions. I guess just pick if you want like maybe a week or so. Yeah.
Thank you.
Yes, ma'am.
Appreciate it.
Of course. Did you get the cause number?
Yes.
There's two.
Anthony Hernandez?
Yeah, please, reinstate both.
Yes, sir.
Tom,
I filed a dismissal in that case. I filed a dismissal.
Are you talking to me?
Yes, I filed a dismissal on when.
I appreciate it. Thank you, sir.
I'll sign it as soon as I get it too, okay?
Thank you, Judge.
All right.
Thank you,
take care.
counsel. Take care. May I be excused, Judge?
Yes, sir. Thanks.
Okay, cool.
Hey, Pons, James, your guy just got a BVR on.
I know, man, how's that? My client, yeah.
Yeah.
Yeah, I've seen him so many times that I feel like he's my brother now.
That seemed positive, so,
I don't,
I'm putting him on for Friday. Let him know he's gotta be here, please.
no, he's here for Thursday.
Okay, so we'll see him Thursday.
Right.
Okay.
And I'm leaving traveling that day, so I guess,
You can zoom.
okay, I'm gonna do my best.
That's why we have it,
Okay.
you know?
But we'll talk about it.
Yeah. We're good, thanks. Mr. Clay, come on up. Good morning.
I have a motion to sub in your queue for 1306.
I'll sign it.
Thank you, Judge. I
Have
appreciate it.
fun.
Judge, that bond violation that you just responded to for Herrera, he's one of our Monday, Thursday testers,
Yeah.
and those are just the confirmed lab results, but we've already addressed all of those results.
When was
Yes,
that?
so they send the bond violation whenever the lab confirms it, and the officer I wasn't here that day that he first tested, so they didn't specify that the results had been addressed already and that no BVR was needed.
Did we address those results?
Yes, we did, because the first ones with like the methamphetamines and everything, that's why we put him on the Monday, Thursday testing. And then the THC was his next.
I don't see a
test.
BVR was ever filed though.
It's impending. Or if you just.
No, I
signed
mean,
it.
when we first got that BVR, it would have been filed as a first BVR
No,
whenever.
it was his first setting that we.
Oh, that was the
yeah.
first set. Got
So
it.
then we tested him.
Okay,
That's a nice on Monday, Thursday.
Got
So
it.
those results.
Okay.
We've already.
thanks. We'll test him again on Thursday to see how he does,
Yes.
regardless.
Yeah.
Come on up.
SHAFI.
Yes. Is she here?
Okay,
Motion a reset, but I think the case is older than 150 days old.
yeah, where are we headed?
We're waiting on the RIP call and the 911 call. I believe the state has sent an escalated request.
Yeah, we've requested the 911 call twice, Your Honor. I'm not sure why it's not in yet. I would just request if we could just have one more sentence while I try and reach out and have somebody to get the 911 in. It is,
Subpoena them to come to court. That's what I would do, you know, so give them 10 days, subpoena them to come to court. And then if they provide it to you, then great. If not, then, you know. But if they can't get you just the 911, then that's as simple as possible, okay?
yes, Your Honor.
So with 10-day discovery hearing. Yes, ma'am.
Thank you.
Sure.
Morning, Judge, my approach.
Oh,
Yeah.
How you doing?
Hi, Mr. Ayala, how are you? What's new?
I've got Serato on your docket, copy for the, like you see.
Thanks, you too. What's new?
Is discovery complete?
Yeah, she's got a bond violation. She failed to show up to a drug screen. She was at work. She did test yesterday. She tested negative.
Great.
Yes, sir.
Okay, is she here now?
She is here.
I'm bringing her.
Yes, ma'am. Yes, sir.
Come on, ma'am.
And I'm gonna reach out to this man with the message.
I'm glad that you tested negative. Good job. Don't miss again, please. Okay, if it happens again, I'm gonna issue a warrant, okay? All right, good luck. Thank you. Thank you. Take care. Yeah.
Oh, go ahead, go ahead.
Hey, Carl.
Hello, Judge. Robert Shelby and the holdover, you wanted to, Bill Stratton had to leave, you wanted to.
You mind? Yeah. Please.
You want me to put it back on to May first?
Oh, that's all.
Robert Shelley, he wasn't.
So I'd like to do PC. I just want to know, because it's a DWI second, but there's also an evading. If you could just give me a brief rendition of what happened, please,
Yes, sir.
when he comes out.
Yes, sir.
So just
Oh, we got Cerna back there? Vic?
no, Judge. It's still on docket. It's been rolling. No,
Do you know who I'm talking about?
Yeah, the being.
Where is this guy? I want to talk to this person. Oh, good, they got it. Okay, so, yeah, roll to tomorrow, please. Yeah, it shows for felony court. Yeah, we'll put him on for tomorrow then.
Yeah.
Morning, Mr. Shelby. So your lawyer was here before I got here and he had to leave to go to a funeral. So I wasn't able at that time to do conditions, but I want to put bond conditions on you because you now stand charged with a driving while intoxicated second offense. You're also charged with evading arrest in a motor vehicle, which that one is a third-degree felony. You're facing up to a minimum of 2 years, a maximum of 10 years in prison. In the Texas in the TVCJ. So can you please give us, you have the right to remain silent. Anything you say can or will be used against you, sir.
On April 3rd, 2025, in Harris County, Texas, an officer observed the defendant's vehicle traveling 117 miles an hour using a rear antenna radar. The officer observed the defendant weave between vehicles in an unsafe manner and a traffic stop was attempted. The defendant passed an available exit with no indication of stopping and ran a red light. After a 20-minute chase, officers stopped the defendant's vehicle using a pit maneuver. The officers moved the scene to a parking lot, and upon contact with the defendant, the officer noticed glossy eyes and bloodshot eyes with an odor of alcoholic beverage. The defendant was identified by his Texas driver's license, and standardized field sobriety tests were conducted. The officers witnessed 4 to 6 clues on the HGM, failed to keep balance on the walk and turn. The defendant refused the one-leg stand. The officer is a drug recognition expert and observed signs of drug intoxication. The SC was read and the defendant refused. A blood warrant was executed and blood was collected.
Can you run his license, please? See his license.
He doesn't know. So
At 117 miles an hour, Mr. Shelby, I am now taking away your privilege to drive. I am appointing you, Mr. Pruitt, here in the interest of justice now because your lawyer's gone to a funeral. But I'm putting these bond conditions on you now. And I want you to know that I will do everything in my power to protect my community at all costs. Do you understand?
Yes.
You are not allowed to drive
Yes.
at all. You will be signing an affidavit. This is a promise that you're going to make to me that you're not going to drive. And if I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand?
Yes, sir.
I'm also ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to put a monitor on your ankle so I know that you're not consuming. You will be tested for drugs and alcohol. If I find that you're using, likewise, I will revoke your bond and put you in jail. If you have a problem with drugs or alcohol, now is the time to address it. Because if you don't, and I see that it becomes a problem while you're on bond, I will address it for you. And I promise you're not going to like the way that I do it. Do you understand?
Yes, sir.
I am now sending notice to DPS that you're not allowed to drive any vehicle that's not equipped with an ignition interlock on it. Every officer in this state will know that if you're pulled over and you don't have an interlock on whatever car you're driving, they will arrest you and put you in jail. And that is a violation of your bond condition here. Do you understand? You're not allowed to drive any vehicle that doesn't have an ignition interlock on it. As it stands now, I'm taking away your privilege to drive, so you're not allowed to drive. You will get a device on your ankle so that we know that you're not consumed.
So he's not required to get the interlock unless you rescind that order for him not to drive?
Correct. You will get a STRAM device within 3 days. Within 3 days of your release, you will be required to get a STRAM device. And if you fail to do it, then your bond is going to be revoked. As it stands now, you haven't made bond on the DWI in your felony case. That's why you're still being held now.
It's a scram device.
It's a device that goes on your ankle so that we detect through perspiration whether you
Yeah,
are consuming.
drugs.
All right. I just wanted to bring you out to give you notice of the condition that we're placing forth on you now. All right? Okay. All right. So we need him to sign this and then sign with Fleischer and then.
Thank you.
All right. Thank you so much, Carl. I appreciate it.
Whatsoever or with for approved and properly said. How to install it.
Yeah.
There's another bit of stuff. It's okay, don't worry about it. Okay. They're here.
You know, I give you the motion.
Mr. Delaney?
Right.
Mr. Delaney, so right, listen. I'm not having this time here about the next ones. And then I have your next one of April 23rd and the two of you, I'm not going to have this picture now, but there's. Mr. Subject, if you have any questions over this procedure, you can contact the child services. Yeah, I just. And then you're all good. No, you're just good. Yeah. I still have the ones that belong, so no girl in the match post. Huh? Oh, really? You? I'll take a show. What are you selling? Oh, you're selling the chocolate? Okay, fine. Can you take, the motions and selling? Okay.
And are you here for,
What kind of bar is it from?
you talked to him?
Yeah. I think it's all, you guys go check it real quick.
Yeah, take your time.
She's got all This is my only.
I don't think that Mr. Jones, huh?
Oh, wait.
So I had, if no, then very probably this.
That's enough.
Hi. Yeah, of course.
I am here on Mr. Gonzalez, Diego Gonzalez. We were waiting here from Ashley Geis. We have not heard back yet, Judge. Reminder that we had applied for PTI. Originally, she said no.
I remember.
Okay. This, yeah.
I know that she was out for a week. When was she out? State, do you remember?
Sorry,
So Judge Geis was out for,
she's back.
how long has she been back, do you know?
Today.
Today's the first day back? Okay, so we'll give it a week then.
No problem. Can I waive his appearance again? Okay, thank you, Judge.
Unless if it's denied, he's gonna be here. If it's approved, could be here to do the TRAS.
Okay.
If it's still no.
It's done. It's done on him. Diego Gonzalez.
So if it's approved, I'll waive it for you to get the contract and all that jazz. If it's denied, he's gonna be here so we can take care of it.
Okay, fair enough. Thanks.
Mr. Jones wasn't brought up today, so I'm just gonna roll him this tomorrow.
They didn't bring him up. What happened?
Didn't come up for Jones, I'm not sure, Judge, but I was gonna vote for tomorrow.
Yeah, but weird. Okay, yeah, obviously we can't do anything without him, right? Okay, yeah, we'll roll it.
There's maybe your approach.
Sure. We had a couple, I was gonna ask you about, if we could review PC on Jeremy Miller.
Always. You said Miller,
Jeremy Miller,
jail or bond?
on bond, waived.
Say it again?
He's waived today, but on.
Okay. So it's a terroristic threat, 156 days. It's
I
a
know,
case.
Your Honor, we've been trying to get in touch with the complainant. But I'll read PC, Your Honor. On November 3rd, 2024, officers were dispatched to 1504 Bench Hall Loop for a terrorist threat call. Upon arrival, officers met with the complainant, who advised she's employed at Benton Hospital as a registered nurse. Complainant advised that she was attempting to administer an IV needle in the arm of the defendant when the defendant stated, quote, "Bitch, take the needle out or I will kill you." Complainant said she took her life.
I mean, why?
So I would argue it's a conditional statement, Judge. It's take the needle out or this will happen. I think based on that, it's not an imminent threat, but it's a conditional. If you do this, I will do this. So I don't think it meets the statute for probable cause.
I mean, Your Honor, I would argue that, threatening to kill her in a hospital.
I mean, can that possibly be the law? So anybody can ever, if there's a condition, then it's never a terroristic threat,
I would need to look at the case law.
That would be,
I know there's someone with agreements.
let me pull up the statute. Hold on, let's see.
But I know that the way it's charged, Your Honor, is imminent serious bodily or death.
A person commits an offense if he threatens to commit any offense involving violence to any person or property with intent to cause a reaction of any type to his threat, place any person in fear of imminent serious bodily injury. I mean, it doesn't say if it's conditioned that, because the statement is he's saying, I'm gonna what?
I said, quote, "Bitch, take the needle out or I'll kill you."
I mean, show me some kind of case law that says that a condition fills it, and then I'm with you. But I mean, there's obviously it's a threat,
I can look at
and the needle's in his arm at the time, right?
Correct.
Yeah, I mean, if you show me that a conditional statement it's no good, then I'm with you.
I also wanted to ask you about Todd Wallace. That's
I remember
Judge
Wallace. How's he doing?
So, Judge, I've not been able to have contact with him. I went by yesterday in person, trying to reach him, and just have not been able to
Said
reach him.
it today because you couldn't get in contact with him, right? Okay. So I guess we'll look at.
And I spoke with Chief. He's essentially leaving the offer on the table of just an apology letter and a dismissal if he does end up back in custody. So I'll
Because
make a
he's-
note of that.
I'll leave that open for setting to Your Honor if he does come back.
Did you put that in the notes
I
there?
put a note in there,
Put
Your
a
Honor.
specific note for
I'm gonna
us.
revoke it now just because you have no contact. If he should show up, then we'll talk.
The exact note I have, Your Honor, is proposed, defendant is going to bond forfeit. When he comes back into custody, I will keep the apology letter offer open for 1
Yeah,
second.
we just don't know what circumstances are going on.
Yeah, I understand.
So, I'll do 1501. Or, sorry, 2501. Hey, so 2501 on Wallace. And I'm not gonna do a BO. Wine your line. Hey, what's up? I like your MSU stuff. It's good stuff.
Thank you.
Back on July, I don't see him in here.
Probably, let me double check.
No, we're.
Eight two, not six. Do you have that on either?
No, he didn't have any of his number.
Like physical address?
Yeah.
9, 111,
I did a great job on these.
Lakes, 6.
So, Greg, 5,002. I'm just gonna revoke
Yeah, I
it.
figured until he
Um,
shows up again.
Yeah.
Okay.
Eventually get them, you know. And at that point, we'll do exactly what we were doing before. We'll do it now.
Hopefully he doesn't pick up a new case in the meantime. But
Yeah.
Yeah, all right, thank you, Judge.
Thanks.
Judge, I did find out too, they will pick up on Saturdays. I wanted to say that yesterday.
Should have done it. Greg, stay on? Will you stay on? Since you know about everything?
Yeah, I mean, that's fine. It's, my concern is say I'm not here for the day and he pops up, but
If he pops up, you can always Zoom. I'll call you. We can always
Fine.
do it through
Yeah.
phone.
I also get someone to fill in if I'm not here on that day. All right. Sorry, we just had.
Judge, may I approach?
Hey, Joe.
We got Mr. Aiden Alexis Martinez, Judge. This is one that we've submitted a mitigation packet to Chief Geis, and we're waiting for a response. So I think we're at the,
Is it under Martinez?
yes, sir.
Got it. Okay. Is everything, they got everything?
Let me make sure real quick, Judge, and I'll see.
Yeah, we emailed the application and the non-driving affidavit and the part mitigation packet.
So assuming everything they got, we'll set you off a week to get everything.
Okay.
And then to the approval or denial. If there's nothing,
Mhm.
if it has not been approved or denied, I'll waive it.
Okay.
And then I'll get on top of them. If it's approved, have they done a T-Res yet?
No, because we're waiting for a
Okay,
response.
so if it's approved, you gotta be here to do a T-Res. Denied, same thing to do something, otherwise.
Yes, sir.
Yeah,
Thanks, Judge.
thanks, Jim.
Thank you.
Now we're ready.
Ready? I don't have something yet. Yeah, that's not good. They said I'll have this
What
paperwork.
happened with upstairs?
We're gonna go on a 15-month defer down here. And it's gonna get resolved.
They're gonna dismiss that one in exchange for this one?
And
And the weed? Got it. Okay. There's not many times that you're gonna be afforded this kind of deal where they're going to dismiss a felony in exchange for a plea on a misdemeanor. So I would be very, very careful. If all this stems from self-control or usage of dope or alcohol, I mean, really, there's some people when they drink, they become the life of the party. They're happy, they're fun to be with, they crack jokes. And then there's some people that turn into the devil incarnate. If that's you, then this should be a wake-up call. If it's not, what's it gonna take, 25? You're charged with two very serious offenses. You have the assault down here, you've got the assault upstairs. They're going to dismiss that felony assault in exchange for this one. You're entering into a very serious probation where it's a 15-month deferred. This is a type of agreement where if you complete it successfully, you do not end up with a conviction on your record, but it's not dismissed. If you complete it, there's no conviction, but you can't tell people it was dismissed. It's not dismissed, just you complete it successfully, you don't end up with a conviction on your record. You need to understand that there's still an affirmative finding of family violence. You pick up another one of these, you're looking at a third-degree felony, another 2 to 10 at the penitentiary. Do you understand? You can also never own a gun or ammunition as a result of this plea bargain agreement as well. Do you understand? Is this what you want to do? You give up nearly every right known to man by entering into this agreement saying, look, I'm going to make it, and if I don't, you can put me in jail for an entire year. That's the agreement that you're entering into now. So for you to complete this successfully, you must do a batter's intervention prevention program. This is a tough one. This is a class that you have to attend once a week for 18 weeks. If you miss it, they're going to kick you out of the program. If you get kicked out, we issue a warrant for your arrest. We'll have a hearing here to see if you violated. No drugs, no alcohol. You will be tested like crazy to ensure that you're not using. You must also do a TRAS. This is an evaluation to see what other conditions you may need. If they assess other conditions, you must fulfill them as well. 20 hours of community service, $100 one-time donation to the family violence provider, no threatening or harassing abusive contact with Mr. Cockrell. Do you have children? I think that in lieu of community service, I would like to do a parenting class. And if she does a parenting class, then I'll waive the community service. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you accept this agreement, you're stuck with this until you complete it successfully or it gets revoked. Do you understand? I like to reward people. You know, I like to encourage people to do well. And what I normally do is if you do well in this agreement, if you don't test positive for dope or alcohol, you get all your classes done and you're nice to everybody, I'll take you off in half the time.
Okay.
So you can be done in half the time. If most, just be nice. Don't pick up any new cases and don't use. You understand? Is this what you want to do? How do you plead to the offense of assault of a family member? Guilty or not guilty? I'm not going to find you guilty now, Miss Loyola. I'm going to wait essentially for 15 months to see if you're able to comply with this. As part of this agreement, the possession of marijuana will be dismissed and your other case upstairs will also be dismissed as well. Do you work, ma'am? Do you get child support for the children or? Okay, cut her fees. It's never about the money. I don't care about the money. I care about you doing what you say you're going to do and showing up and doing it on time. The worst possible thing you can do is either pick up a new case or abscond. You just take off. That's an instant warrant in this case. You understand? So if you ever have any problems, come back. We can always work through it. We can talk about it, but just doing nothing and taking off, it's the worst thing that can possibly happen. All right, so I'll follow the agreement, send it you to everything. Good luck to you, man. Please. I've never heard of the family violence provider. Is that the Houston area women's shelter?
Yeah, it's statutory. It's the $100 donation you're talking about. Or
Blaze.
the location. That's,
You said the family, huh? Oh, Sebastian put this on there?
the way he said it was like mandatory that, I don't know.
No, I get it, but I've never heard. Do you know what this is referring
From
to?
what I understand, it's actual programs that the probation officer was directed to regarding.
No, the $100 fee to the family violence provider. Do you know who that goes to?
Not directly.
I'll email Sebastian and see.
I've never heard of that before. Houston Area Women's Center, I've heard,
Yeah.
right? Or MAD, but because normally in these types of cases, we do it to the hawk, you know, so.
I asked, I just
Okay.
knew it was mandatory, statutory for the $100 donation, but where, they chose that.
I don't know if it's like a shelter. I'll have Sebastian email provide information and try to see what that.
Judge, I got you. We're still waiting for the paperwork, Judge. But I did want to talk to you about Ms. Free. Let me ask Richard real quick, because we're just waiting for the, Ms. Free. We're just waiting for the PTI.
What do we do with this, Ms. Free?
Yeah, we're waiting for them to give us the PTI contract. She's turned in her application on that. I just forgot to ask Richard real quick.
State, is Ms. Free, is she approved for the PTI program?
She should be, Judge. She's like a 0.1, she's like a. She's a 0.13, no crash. We've already turned in the application.
Still pending approval, Your Honor. There's no crash, no.
No, I mean, it's just a 0.13, just, you know, I mean, it should be pretty standard PTI case.
If I could just have a moment to talk to Chief Younger, and I'll.
Well, we probably need to reset anyway for them to get everything ready.
I know, but at least we can get the approval so they can get you the contract.
It should be. No worries, I mean.
Still not.
Still not. Okay.
Are we on today?
We're not just, we're just waiting to let that county board when they come by, kind of give you an update.
What's the word, Thunderbird?
Deal was still approached the judge and he was not there.
Do what?
Judge wasn't on the
Judge
bench.
Morton was off the bench.
He was off the bench, so,
You just reset it?
we got it reset, Judge. We are still waiting on, a couple things.
I'm just digging into whatever else I can still find, Judge. Lyft gave me some basic account records, so I wrote a search warrant to get the entirety of whatever records they have. And trying to see if I can get some call logs or historical data from his client's phone. My division chief just got out of a week-long trial, week and a half with the DA, so I know he wants to
Is
come
that the one that
down.
was yesterday?
Yeah, and I've obviously been sitting on that one too for the last week, so we're hoping to.
How long do you want to reset it?
We're set, I think, on Monday.
Oh, yeah.
We're set on
The
Monday
felony,
in
yeah.
here. We just figured since we were here.
No, you might as well. There's no sense in wasting time. So, yeah, whatever, what did you date? Did you get something upstairs?
We got a date, it's June 10th.
10th?
Okay, I guess set it for the same day. Are you gonna have everything by then? Promise?
Yes.
Cross your eye? Hope none.
Eye, heart,
A needle in your
whatever.
eye?
Yes.
Okay, all right.
Thank you. Have a
you,
good
Judge.
day.
It's on Docket, it's tomorrow. Oh my God, there's superstars. Oh.
Hey, Judge, Aviles,
Page one,
Okay.
just waiting on, DPS to, send their evidence over.
It's 150 days. You don't have anything? What?
No, we have evidence we need from DPS, so we sent it over and it hasn't been released. So,
Can you tell me the name one more time? What's-
Aviles,
Sorry.
so that,
I have
so
a
usually what
problem.
happens is that you sign that document, the standing order, we send it over to them, and then when it's available, they release it to DPS, to DAs.
Sure. But if you've sent it over a while ago and they still haven't given it, I'm gonna have a problem with that. You sent it in December. We're now 4 freaking months later and you still don't have it? That's unacceptable. So I'll set it for a 10-day discovery hearing, and if they don't have it, it doesn't get used. It's unacceptable to wait for 4 months for evidence. So, no. So,
Yeah, it probably is delayed, 'cause it's on the.
I just listened to you.
Oh, I have it. So then we just need a regular reset then, Judge.
I'll give you a regular reset. Do you have an offer? Have you given them an offer?
Your office, your honor.
So at the next setting, you gotta let us know what you wanna do. By then it'll be 180. Okay?
Sounds good, yeah.
Okay, have fun.
Here's a pro tip, don't go to 174 or the 176. Yeah, like,
Really?
don't go. Given a choice, just don't go.
what, I do so.
So I'm live streaming, you don't, just,
Exactly.
Well, I mean, I'm open about my distrust and hatred for the 19th floor, which has been mitigated by the election of Toto. Oh, I'm sorry, I forgot to say hi.
yeah, so she just got out of that big trial, huh? Man,
Yeah, I think she was trying something. All I see
was
on
that,
Facebook
in
is
talks,
her new
man?
weddings.
Hmm?
She's done like 15 weddings or something since she took the bench.
Already?
Yeah, how many weddings do you do?
I've never done one.
So how does she do all these weddings? I know as a JP,
You get paid for it too?
so in JP court,
I know JP's making.
it's a good
like
side hustle. As a district
Under
court,
GERB, just crazy money for
yeah,
weddings.
a district court, or county court, I don't know.
I don't-
Yeah. I've got an off docket thing, Judge, you asked me to approach on. Okay.
Just do this.
Okay, you want to-
Sorry.
Yeah.
Just give me 2 seconds, let me get them out.
You're fine.
Coming up, sir.
This time.
Good morning, Mr. Pack. You sure you want to do this?
As we talked about probation, we talked about, the
You
different
have no
choices they have.
convictions. You have no as far as I see, no convictions. Now, after today, you're gonna end up with a conviction on your record. From now on, you're looking at 90 days in jail for any new cases that you pick up, you know?
Yeah, the choice is, you know, you can get the defer, you can get the probation that we talked about, but you decided to do the time.
When you plead guilty to something, it goes on your record and it stays there for the rest of your life. You can never take it off. And it will affect you when you try to get a job, try to buy a house, try to get a car, a loan for something, try to get an apartment. So that's what I'm saying. I mean, you're old enough to know that.
I was lost when you was like 90 days at the.
No,
I was lost because.
No, what I'm saying, you pick up anything else in the future, from now on, it's a minimum of 90 days if you take this deal. Because they can enhance your punishment to a minimum of 90 days in the future.
You're not getting that as a time served deal. The judge
I'm
just
served
want-
here, but what I'm saying is, you don't want to defer to try to keep it off? You just,
Sir, if you look at the computer, I've been at TDCJ before. It don't matter. It don't matter.
That's,
I'm just gonna
that's
be
not
honest with
necessary.
you. It don't
I
matter.
don't see, I only get access to Harris County because I can't get them to give me access to anything else anyway.
I
So,
understand, but I can tell you, you know, I
Okay.
had my time, I done did my lesson, so if time served, I don't have to go to jail, I don't have to look over my shoulder, that's fine with me. I walk a straight line. That just was unfortunate happened with my problem.
you're charged with resisting arrest, you're facing up to a year in jail and or a $4,000 fine. You've worked out an agreement where they're offering you 3 days in jail with credit for the 2 days that you've done. Like I said, this is gonna go on your record, it'll be there for the rest of your life. You're giving up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you plead guilty, that's it.
I understand.
This is what you want to do.
Yes, sir.
How do you plead to the offense?
I plead guilty.
I'm going to find you guilty. I'll follow it. Good luck to you, Mr. Pack.
Give me
Take
1
care.
second, get you this piece of paper, go downstairs so you have to make more copies.
All right.
I'll be with you in a second.
Hi. Yes, ma'am.
Mr. Williams on your bond docket, Tavion, this is first name. He came back to court today.
Brazier?
Williams, I'm sorry.
Oh, this is the dude from yesterday.
Yes, and he is
Okay.
present. Talked to Procedural Services, the labs did come back positive for THC. Yes, Judge.
Okay, come on up.
I think the offense date was March the 30th, sir, so a little more.
No more.
Sure.
I'm going to test you 50 days from today.
Sure.
If I find that you continue to use, it's not going to go well for you. Do you understand? Do you have a job?
No, not at the moment.
It's time. It's time for you to start working and being productive. When you have too much time on your hands, you become self-destructive. That's what we don't want. I don't want you to pick up a 6th case or 7th case now within the next, that's it. I'm going to bring you back in 2.5 to 3 weeks and I want to see what you have done to get a job. If you've done nothing, you understand. All right, good luck.
And he did let me know he has enrolled in HCC for the summer session of college.
That would be great. That's great. But if you're taking 6 hours, you got to do something else as well. If you're taking a full load, then great. The more schooling you do, the more money you're going to make in this life. Knowledge is power, and with knowledge, you get money. That's what this life is about, not convictions. Do you understand?
Sir.
Good luck. Thank you. Yes, ma'am. All right. Is this from Mr. Wiggins from yesterday?
No. This is, Mr. Broussard, who's the fellow who's in the mental hospital, which reminds me.
I remember. Yeah.
Can we turn the lights off? There will be discussion of HIPAA-related information. I gotta look at it. You're welcome.
All right, you want to go through the list? Let's be done.
All right, Judge, bottom of page 13, all he said is
I mean, it's a second time.
That's what I told him. I said, it's the second bottom, I'm not sure.
So he can pick another day this week.
Okay.
SFBF.
Next one is.
Really?
So. Oh, page 21, Wilkins.
All right, I guess do SFBF Friday.
Friday?
Yeah. You said Wilkins?
Yes, but on page 21, you found Wilkins C. Are we expecting snow?
Hey, what do you want to do with Wilkins? That's the theft from the bike or,
I just want to talk. We're not missing anything here. Because Judge, I agree with you. I just want to make sure that we're not missing something here.
Okay, I'll put it on for 4:28.
Thank you.
okay.
So Judge, we're waiting on James Sims. He has 3 cases open and that's it. We're done. Oh, did we get all our dismissals?
What are they gonna do after that?
Do y'all have all y'all's dismissals?
Which Sims cases are you talking about?
He has on page 17 and 18.
Okay, hold on.
Yes.
Okay, so Smith, we're doing that 1 week.
Yes, but I
To appear.
did a date for them.
That's okay. Yeah, I get it. Who's
And
next?
then the other one is page 22, Willis. It's the AFM.
Okay, so you're just gonna get a reset.
Yep.
Okay, who's next?
The other one's in custody. Page 28, that one, you wanted a TRS done in custody, which is done. And recommendations.
Local court is local complaint. Drops down to community potential, high risk. Need of practice with IUPS.
Possession or nothing.
So it was sober court.
Is her name Lola?
Loyola.
Lola?
A dismissal for Loyola. Yeah.
I'm down with either. So whatever Mr. Sims wants to do. If we do sober court, though, he's gonna have to go do orientation first and then he does the plea. Am I right?
The probation officer can assist with that.
Hmm?
Would his probation officer assist with that?
When we do sober court on someone, because it's been a while, don't they go to orientation first and then we do it? Because they have to go through orientation and then agree. But the problem is he's in custody. So how do you do orientation?
And I haven't done server board. John, you know?
That's a lot of water.
I think I did veterans court not that long ago, Your Honor, with the defendant, and they had to go through orientation. I think it's similar. They just go through orientation and then they take.
Are they in custody though?
I have no idea about any custody, Your Honor.
I would assume that if he's pleading to go server board, that he would be getting out, right? It's
I
probation.
don't know. I guess look into it and look into it and see what the parameters are with sober court for someone who's in custody.
Because he wouldn't have bond, because bond would be done, and there would be nothing holding him unless he had some sort of warrant or hold.
Yeah, I don't know.
Assuming he'd get out.
What, so if he pleads to probation, the program that he's waiting on in custody,
Yeah.
then it's still possible.
But I don't.
No, but he does orientation first for sober court, then he does the plea.
So he pleads here and then after orientation, we get the silver court, which court it goes to. Yeah, that's the way it goes. He'll plead and then we find out after orientation, which court gets it.
Okay, then we'll do that.
And then later I have to do a transfer order, it's checking silver court.
Okay, so if he wants to do that, then let me know. We'll roll it to tomorrow because I gotta go to the meeting. And then we can do it tomorrow.
in there? Can you hear me?
Ms. Bauer, are you on this?
No, Your Honor.
Well, okay, I just need you to know that the answer to the complaint has you listed as the defendant's attorney.
was just providing technical assistance to minutes. Ms. Berger, I just said in the email that I was assisting her in getting it filed, but I didn't appear on the case.
Okay. All right. What are we doing? Your name? Your name? All right. Where are we on this?
Your Honor, Ms. Stoneberger did not pay her escrow. She was ordered to answer, I think she got her answer in nominally on time, but she did not pay her escrow.
Yes, I did. I can't deny the other 550 was going to be given to me, but it was not. And so I do agree with that.
550 was paid on April 3rd, according to our records.
Order was for 1,100.
Yes. Where's the balance of that, ma'am?
Balance of 550. I was, be honest, the other occupant and stuff was supposed to have given it, he did not, and I cannot come up with the money my own self. So I paid my I could deny.
Yeah, they're in advice of the room, Your Honor. The other occupants unauthorized. So that's part of the reason. Blatant determination is that she's got unauthorized occupants in the unit without permission of the landlord. And it's a violation of release.
The answer is late also, but this is a termination of tenancy case. Is that correct? Well, you haven't complied with the escrow order and the answer was late. I'm looking at it, deciding whether or not I should strike the answer. But in any event, plaintiff is entitled to an immediate trial on the issue of possession. So are you prepared and ready to go to trial, ma'am? Pardon? You are? Okay. You have your client here or? Okay. The basis for the termination?
Basis of termination was damage caused by the unauthorized occupant, flooded the house, causing several $100 of damages. Would have been more if he had done a lot of work himself. But it caused a flood above him, which caused the ceiling to collapse. It denied responsibility for it. Well, actually, what she said is talk to the other guy, the unauthorized occupant, he's responsible for it. So there's damage to the premises. Two unauthorized occupants living with her. She's in violation of release. Frankly, I don't think she's already admitted that the other occupant didn't pay his supposed debt escrow. So her own admissions are that she's got somebody else there that's in violation of release. I don't frankly think there's a threat.
And what's your position, Ms. Stoneman?
Yes, sir. Yes, Your Honor. We signed a lease back in October with Mr. Plummer, with Chad from CMH that paid the amount and a security deposit, which Mr. Kevin Salisbury is on that. When me and Kevin Salisbury had an argument, Your Honor, I went to my landlord. He ripped it up in front of me, the original one.
The original one.
The original lease. And then we made up a new lease, which also he did not give, permission to Mr. Kevin Salisbury that he was terminated. He never evicted Mr. Salisbury from the tenancy. He just ripped up the lease and had me do a new lease without consulting Mr. Kevin Salisbury about it. So that original lease should still take place, and I am also guilty with Mr.
Well, do I have a copy of that legend?
The first lease?
Yeah,
Yes, I sat there and gave it back to Mr. Palmer, which he knew this. And,
well, but do I have a copy of it?
No, I don't think so. Everyone. Because Mr. Shad said he didn't have enough accredited time from CMH that he does have a copy of the original lease with Kevin Salisbury on it, I'm on it. And there was a verbal agreement with Mr. Palmer, knowing that my 15-year-old daughter worked very hard for 3 years to get sole custody of her, and he knew this. And he said we didn't have to add her because she was a 15-year-old. And
What happened with the damage to the premise?
that, sir, he called me on my phone, and I was at work.
He who?
Mr. Palmer called me, and he said there's water going upstairs. I said, well, I'm at work. Knowing that he's a landlord with a key, if he knew there was probable damage, sir, that the expensive water was running, he has permission to go into my apartment with his key to go and check on that damage. Your Honor, I have never heard of this after that. Nothing. I've never seen a bill, never seen anything. I paid my security deposit, so if he had out of pocket expenses, sir, he should have used my security deposit.
She can't do that. So why'd you sign this other lease?
Out of anger. And I went back to Mr. Palmer and I told him there, and he had no problem. Maybe I should have talked to him under different circumstances, Your Honor. With Mr. Palmer, sometimes I will not say this. I will not hire car, but Your Honor, my thing is if he had damages, I wish he would have shown me proof. But he did have access to my apartment. No, he had a key to it.
I mean, you're not claiming that there aren't damages.
I don't know if there is, or he never gave me no proof.
Who is it you say has this other lease?
I mean, Mr. Palmer. That's who I handed it to.
But you said somebody else has another copy?
Yeah, for CMH, yes, sir. And he didn't have an adequate enough time, and I've also.
What do you mean he didn't have adequate enough time?
When I went and talked to him about it, he said it's gonna take time to do up everything, and he knew that I had court today. I put that in my written statement. I also stated that, I asked for, for him to give me proof. If he can give me proof that there was damages and that he could work on the floor, that it was flooded, he should have some kind of record of the cost of that. So if he did have that cost, then he'd be able to take it up.
So is this other individual residing in the premises?
Yes, he is. And he is willing, I think he's gonna make his own motion with Mr. Palmer.
His own what?
He's gonna be taking Mr. Palmer himself to court. Off late trying to whatever, because he still legally should be able to be there with the lease that his grandmother has, or whatever he's trying to find. And my daughter, sir, she's 15 years old, Mr. Palmer. And I'm not saying this, but normally, I mean, my daddy always said handshake is better than. And I did trust Mr. Palmer's word, and he trusted mine. And I'm guilty of, some things myself. I'm not saying that.
Was there another lease, Mr. Friedman?
In other words, Your Honor, the lease that's in place is the lease with her alone, one occupant, her. They had no other occupants are authorized.
So I guess my question is a little bit more specific than that. what I hear the defendant indicating is that there was a lease that included two people. That somehow what she's basically claiming is that impermissibly that lease was terminated and this lease signed. Is that correct? Do you know?
I'll answer your phone. Yes, it was.
Do I have a copy of that other lease?
It was destroyed. It was destroyed.
Yeah. Under what basis then was that lease terminated and this new one put in place?
When the man in question took her car and totaled it, I mean, I didn't see him. She said, I don't want him here. He's here, he's trespassing. Is there any way we could rewrite something so he cannot be here? So I said, are you sure? I said, give me the only sole copy of that lease. And I destroyed it. I shredded it, put the lease for her, so she wouldn't have to worry about this person bothering her. And then he shows up right before the holiday and said, oh, he's my guest for the holidays. Starting before Christmas and continuing until today. I mean, still there. And then 3 weeks ago.
All right, well, how long, that would not be a proper way, just on the face of it, to terminate the lease, the previous lease, and then enter into this next agreement
He had left.
and then seek to evict her for what may have been that prior agreement. I mean, there, go ahead, Mr.
He left and
I don't.
And so, and basically, I mean, and she's saying, I don't want him around. He's destroying my car. He's left. I don't want him around. I want a new lease. So he does,
But how, but the question is how was his interest in the property as a tenant terminated? I mean, I mean, we get into a very strange world if leases can be terminated by somebody tearing up the lease.
So he did abandon the premises.
Do you agree with that, ma'am, that he abandoned?
He did leave because he was in the hospital, Your Honor. He did total my vehicle. He was in the hospital for a week. He definitely came back, and that's when Mr. Palmer called me about the water, Your Honor. During that time, he already knew Mr. Salisbury was staying there. He knew this. How come he knew about that?
Okay, so how long did this gentleman leave for?
About 5 days in the hospital, and I think that proved.
Well, okay, so hold on. You and this other gentleman are in some type of relationship, with that being the case? And so, as I hear it, Mr. Palmer, something happens as a part of their relationship. She tells you, and then you tear up the other agreement and enter into this new agreement. Is that?
Yes, she said he was gone. She didn't want anything to do with him, doesn't want him there because he's trespassing. So to save her from, I don't know what kind of trouble, she said he's not coming back. She said, no, I don't want anything to do with him. I'm done. It's done. So I said, well.
Okay, so how many times have you heard that in a relationship? I mean,
I don't.
I mean,
I'm sorry, I just don't deal with it. I'm just wondering.
no, I'm just saying,
I just.
I mean, on behalf, all parties, at some point, will tell anybody else, I don't want somebody there. I mean.
He was physically gone. He'd taken her car. He totaled her car. He was in the hospital for 5 days. The day he came back was the day she left, I guess. And when he turned the shower on, I don't know, it was running for an hour at least. I'm banging on the door, banging on the ceiling. I knew somebody was in there, so I didn't want to go just walking in there. As she said that I had keys to enter the property.
Which you do.
Yes, but I didn't want to just go walking in there. I'm banging on the door. Somebody was physically in there. I didn't know what was going on. I couldn't turn the water off on my half, so.
So then. I'm not even clear what to do with this because I've got this other lease that sounds to me like it's not properly terminated.
Doesn't exist. Well, Your Honor, it seems to me though that the only person that would have any standing to raise that issue would be the dude, whatever. And he's not here.
Well, no, the defendant has standing to raise the issue because if part of the reason you're terminating her or the basis for the termination is that she has this unauthorized occupant. And then two unauthorized occupants, who's the other one? Oh, for,
He's basically in a pretty good deal for both Mr. Palmer when I did it.
how old's your daughter?
She's 15.
So you're claiming that's an unauthorized occupant?
She didn't have the daughter when she signed the lease. She was in custody.
And now you have custody.
Yes, so after 3 years, I had custody. Mr. Palmer knew it.
So what am I to do with this daughter?
Well,
I mean, am I supposed to tell her her mother, oh yeah, you fought for custody of your daughter, but she can't stay there with you and your lease is being terminated. So I'm now, because you fought for custody of your daughter, you're now going to be homeless. Is that what is that the position that plaintiff is taking?
That's not the position plaintiff's taking. We're saying is that when you add it all up, there was supposed to be one occupant, now there's three.
Well, no, because Miss Salisbury, the other lease, there were two occupants. And so so maybe there's three now. And then I'd have to figure out what to do with, I guess, this newfound daughter. And then
There's another 800-pound girl in the room, which is there hasn't been any rent paid since January.
They charge for rent in January 800, but 1150, and there hasn't been any payment from February to March, which is the tune of $4,400.
go ahead.
With the damages and stuff, also that he's trying to terminate my original termination. Is he never forthcome when he called me, I was at work. He talked to me about the water. I said, Mr. Palmer, I'm sorry, I am at work. And he says, okay, I called back again within a couple of hours and it was off Tenancy. And that is the last time I heard from Mr. Palmer on the issue of any damages. Never seen a piece of paper, never seen any damages.
Do I have anything about the damages since everybody wants to go there? I mean, I'm still stuck on this lease thing. But does she have a copy? Go ahead, take a look at it, ma'am.
I have never seen this, the first time I've ever seen.
No, I know, but take a look at it. Do you have any objection to the court seeing that?
No, let me see.
Well, hold on. Do you have any objection to me looking at it? Because I don't know what you start talking and I don't know what you're talking about. Okay, so. Who's this from?
A contractor?
Okay, does the contractor, does the contractor have a name?
Yes, Jeremy.
We have the photos of the damage. Let's see.
No, I understand that, but
Madam, may I speak one more time?
No, not right now. Sometimes it's better not when you're ahead. So it's $625.
Yes, sir.
Okay, but have you paid this?
Yes, I have.
Is there a receipt for the payment?
I can get one from them, but I just paid them cash, gave you that as a receipt. As it says there, paid final amount.
By somebody who it doesn't. Okay.
If you see the pictures, you'll see the 625 is a bargain.
Okay, I don't. Here's the problem that I see. First thing is this other lease. Because I don't know if this other lease is the same as this lease, but just the names change, or if there's something different in it. I don't know that. That's the first thing. Second thing is I am still unclear as to how he, in essence, terminated a tenancy by tearing a document. Because the reality of what he did would not only be to terminate the tenancy of the other individual, it actually terminated her tenancy, and then she enters into a new tenancy, supposedly. But I don't know that that first tenancy was properly terminated. If it's not properly terminated, there's at least an argument that this lease that you're seeking to terminate her is void or voidable, and that other lease is the one that applies. All right, that's my just initial thought on this.
Sir, man,
Go for it.
I
don't know why you were involved in their relationship. So go ahead and you tell me what you want to tell me.
I was not at all. I thought, by the way things have went for her, and she was coming to me and saying, hey, I don't want him here. Basically scared of them. I don't know what the situation was. If he's here, he's trespassing. Can we do this? Her and I stood there, and that's what we agreed to do the new lease.
I wonder if I could have done that with my mortgage company, Maxwell. Could I? I mean, I'm just asking. I mean, if stuff works that way. Alan? Okay, all right, I'm just checking.
I think this is the thing where he thought he was doing her a favor, and
I know, but I get that. Good Samaritan and all that wonderful stuff. But then I'm now here, and because this guy came back that she may have been mad at him for a while. They patch their differences. I don't know, her car gets repaired, whatever. And then because she does that, and because there's this damage, I get the damage part, but because she does that, the one basis upon which now she's being terminated, it seems, is because she repaired her relationship, and also is being terminated, I guess, because she was successful in fighting for custody of her daughter. This is a beautiful scenario.
well, we didn't raise the daughter issue, but it's.
Well, no, he did. I mean, so let me ask this, Mr. Friedman. Is part of the basis for this other person her daughter? Part of the basis is that she has unauthorized occupants. Is your client claiming that the daughter, the minor child?
We didn't mention the daughter.
Okay, so is that an issue?
We're not raising it. It's a fact.
Well, he
It's a
did.
fact.
Okay, but when I said there's an unauthorized occupant, somebody said two. And so one of those would be her daughter. So what I'm asking is part of the claim in this case, the daughter in the premises?
No. It's a fact, but it's not, we wouldn't have terminated the tenancy because of that, no. We terminated.
Okay, so I don't have to worry about the daughter. Okay,
But we do.
I just have to worry about this guy that she got mad at, that all of a sudden the lease gets torn up, that then they repair their relationship and now he's an unauthorized occupant. That's the only one I have to worry about.
And the fact that he caused the damage, yes.
Okay, I mean, we can get to the damage part, but and what?
They haven't paid rent since January.
Okay, but I've got a termination case
I
in front of me.
understand, but you're gonna have, it's a 7-day case in 8 days.
Okay, so, ma'am, the individual that has a copy of this initial lease, how long did they say that would take them to get?
I did propose to Mr. Palmer through Ms. Jill, that I would like to be out by May 31st. I'm willing to give the security deposit by 50, and I'm also willing to pay the first month's rent in May by the 1st of $1,100. I would like to be out by May 31st.
So you want to pay $1,100. He keeps the security deposit, you don't have any claim over it, and you just want to be there till May 31st. Well, hold on. Yeah, there could be an immediate trial. However, I've started a trial, I guess, but I've got an issue because of this other lease. So, and it's not here because your client says it's destroyed. She says there's a copy that exists, but she can't access it at this point. She's going to try to access it today. So it would seem to me that I would adjourn this in any event.
I understand. This is my first trial. My first time.
I know. Yeah, I know. You can see where it's going.
But I would say this, if I was inclined to make that suggestion, I would want a COD because
and I think that could be in a COD. She seems very definite that she's going to do these things and then leave. I don't think your client likes the idea. So why don't I just adjourn the trial? And my next date isn't until like late April anyway. Huh?
April 22nd.
So it would be April 22nd. We'd have a trial. I don't know how long it would last. We might get till the end of May in any event. But I mean, if that's her proposal, it seems like a reasonable one. She doesn't want to stay. And by the way, the other thing that's faced is that if I find that the lease here is void and or voidable, you're going to lose anyway. Once I see that second lease. Or at least there's the potential. So here's what I'll do. You're going to get a copy of that other lease. I'll adjourn the non-jury trial to April 22nd, 2025 at 9 a.m. And something we've learned today. If your lovely wife starts yelling at you, just give her a notice to quit. All right.
I do want to do a request for escrow. Give it back.
I understand, and that would be my next available date for a trial. So you're entitled to an immediate trial, and she's gonna pay her escrow. Bye. I guess she's leaving. Okay. All right. Thank you. No, really? I hear you. Just tear it up. Wow. All right, I'm just saying.
Approach it, something else.
Yes, you may. Okay, court does call the case of R&J Group Holdings versus Saffold. I think it's Saffold.
Anthony Molina, appearing on behalf of R&J Holdings, Lane.
Good morning, Your Honor. This is Dr. Rosado Stafford on behalf of myself.
All right. Have the parties tried to talk at all or no? Or are we gonna go to trial?
No, there's no talking, unfortunately. I'd be willing if the court would direct us to, but I don't think there's anything we can discuss. It's a termination tenancy case. Talk about it.
Your Honor, I'm open to talks and communication is not a good strategy, but this is not a tenancy termination. This is a purchase agreement, the subsequent tenancy that we signed is Exhibit G with this gentleman's clients. And it's dated November 17 of 2024. Signed the purchase agreement that we want this to be enforced as a matter of fact.
Yeah, but I can't enforce the purchase agreement. You've been to other courts to enforce that purchase agreement, correct? Then what was the complaint in federal court?
Court case, Your Honor, is a wrongful foreclosure suit against Wells Fargo that subsequently we added and amended the complaint and added R&J to that case. That's why.
And then that case, did he give you?
Yeah, I just need contact information and then call back. He could see me during today.
Ah, wonderful. Hold on. Where did Mr. Chavez go? I'm gonna break in this case, recall Evergreen versus Chavez. I need you, what do we need? We need
I need contact information for Mr. Chavez and then just some general information about
the dog, and then they can see you.
They can see me when you're done.
No, once that happens.
I will call back the Humane Society and they could see them sometime this afternoon, tomorrow, depending on your availability. They'll make it happen.
It could be today
Okay, yes,
because he got somebody with him. So, okay. So we'll get that information. She'll come out, get that information from you. I'll adjourn this matter out to my next date, which is April 22nd, 2025 at 9 a.m. Okay?
Your Honor, can I?
Yes.
One thing I would say is if potentially Mr. Chavez's caseworker could maybe help him apply for mental assistance in the meantime as well. Yes.
Yeah, I think they were working on that piece also, but we weren't going to get anywhere until the dog got his shots.
Yeah.
So, okay. All right, great.
Oh,
All right, so get all of that and then we'll. And do you have copies of the previous make sure to have with him a copy of the previous vet records to take with him down there. Okay, so that, all right, we'll get it taken care of today. Thank you, folks. All right, we're back on the our R&J Group Holdings. All right, the question. You added R&J to the federal case, correct?
Correct.
And then that case was dismissed.
It was not.
Okay, is it pending?
Yes.
And did you get a stay of these proceedings in federal court?
I didn't petition for a stay in federal court. I'm petitioning to this court for a stay. Your Honor.
That stay is denied. I'm not issuing a stay. So, ma'am, I'm trying to figure out what's your claim. Because I read through everything that you filed before the court, much of it, which was also stricken, but then you filed other things. You haven't complied with that. As to the issue of possession, I don't see that there's an issue for me to try.
Issue of possession is a non-issue. First of all, according to the lease, the court that has jurisdiction, we agreed on that, is the Circuit Court of Oakland County on Section 13 of the lease. Excuse me.
I don't think you can't confer jurisdiction that way.
Well, they have
What?
They have put in that lease agreement that in case of conflict, we have to go to Oakland County Circuit Court.
Yes, but the property resides in Washington.
Correct, I agree with you.
Then venue and jurisdiction is here. Hey, you can't do it that way. Even if that was agreed to, it's unenforceable.
I agree.
Okay, so we're here. So everybody doesn't have to head to Oakland County. It might make my day easier if you would, but you can't. Okay, so it's here. And so when I look at everything, I don't see as to these two parties that there's anything for me to try, that they're entitled to possession of the premises.
Despite the purchase agreement they signed?
The purchase agreement, you're making that part of, did you file an action in circuit court regarding the purchase agreement?
I'm intending to do that.
But you haven't. And they're saying you defaulted on the purchase agreement.
You're wrong.
Okay. But if you're seeking to enforce the purchase of the property, can't do that here.
The lease agreement has a provision that within a year we are entitled to purchase the property. That's what we're trying to do. To buy the
Okay,
property.
have you purchased it?
We secured the loan. We ordered the title work. The title work shows that there is a lien on the property and the mortgage company would not issue any loans to me unless the lien is removed by Mr. Molina's client.
Sir, what's your position on this?
That's simply not true, Your Honor. There were two liens on the property. One of them was a mortgage lien that's paid at closing.
Right.
Proceeds of the sale. The other was a lien that was placed on the property by the homeowners association by virtue of her actions while she was in the property before. That aside, we did obtain title commitment, guaranteeing her clear title at the closing. And I've got documentation and we submitted that to her mortgage agent and her prior to the date the closing had to occur. So that's simply not a true statement.
And the closing hasn't occurred.
We submitted the documents that they gave us to our mortgage person and to the title company, and neither one of them
So let me ask you this. Are you gonna let her buy the property? Or do you want it back?
Today, we want it back. If she wants to negotiate or buy it later, that's fine with us. We're not opposed to her having the property. What we're opposed to is her staying in it for free subsequent to the chronological termination of the lease. So my client does want it back, and I'm not sure at this point whether he wants to sell it to her, but I shouldn't say that he does. But there's nothing personal here. We just want our property back because we're entitled legally to it. And there was no breach on our side of the purchase agreement, period, in our opinion. I have documentation.
No, I looked at everything. I don't see any breach regarding the purchase agreement. It's just.
Yes, there is, Your Honor. May I speak?
Well, why haven't you brought an action for the breach of the purchase agreement?
Because they brought an action for possession. I'm busy responding to that.
Go ahead. What do you want to say? What do you want to say?
I'm sorry.
What do you want to say?
What I want to say is the gentleman's statement is absolutely incorrect. We have paid money to run the title, and since they purchased the property, they are the violator of the lease agreement because they were not supposed to get a mortgage on this property. They have. Also, there is a fee on the property that prevents us from going forward with the purchase of the property because of the lien, and the lien is not removed, and it happened when they own the property, not we own the property.
The lease has expired.
The lease has expired, but the.
And then, but hold on, ma'am. The lease has expired. You're seeking to enforce this purchase agreement.
Correct.
That's not done here. That's why I'm saying I don't have a tribal issue. The lease has expired. They filed proper notice. They're entitled to possession of the premises. If you wish then to enforce your rights regarding that purchase agreement, that's going to have to be filed in another court.
Okay.
I mean, I think it's as simple as that. Is there anything else you want to tell me?
So I'm here today fighting for my, this is my primary residence. They promised they're gonna sell it to me. They are backing up from their promise. They broke every single provision in that.
Okay, ma'am, you can tell me that all day and night long.
That's fine.
And the problem is that has to be heard someplace else. It can't be heard here because the lease expired. They're seeking possession of the premises. So court after hearings finding no tribal issue, granted judgment for possession to the plaintiff. There is no redemption amount per se. What I will do, ma'am, is normally a writ would issue in 10 days, but you can I'll indicate that a writ may issue April 30th. Then if you wish to file some action or seek a stay, you can do whatever you want to do, but I'm gonna have a writ issue April 30th.
Also, I put a $5,000 in escrow and that be released
To whom?
to myself.
Um,
If I may briefly.
you could say, go ahead.
Rent is due prior to the end of the termination of the lease, so we're not accepting any rent for periods of after the expiration, so I believe my client's entitled to that.
I beg the difference, Your Honor. They are saying that lease was terminated as of November 1st, and I paid them October payment. So as of November 1st, they are not entitled. If they claim this lease is void and null. Excuse me.
You guys done? 'Cause here's what I'm gonna do. I'm gonna issue the judgment,
Okay,
okay? Writ date of April 30th. I'll set a hearing on the release of escrow for May 20th, 2025, after I see where the landscape is. All right?
thank you, Your Honor.
Same
God
10-day
bless you,
appeal
Your Honor.
period. Same 10-day appeal period in the.
On the judgment, you mean? Yes, correct.
Thank you.
Thank you.
I'll prepare to submit it to you.
All right, thank you, sir. You guys do the same. Thank you. And Chavez, I did something with that, right?
You adjourned it.
Yeah. That day. And then. That's all I have. 14A stands adjourned.